Thank you.
It doesn't really make any difference on which side you sit. Good morning, Mr. Fox. You're going first, correct? Please proceed.
May it please the Court, I'm Robert Fox and represent the respondent, Randy Sargent. The primary issue in deciding this case, I would suggest, is, in general, Mr. Sargent's right to counsel during the 60-day temporary confinement where he's interviewed by the qualified examiner.
Mr. Fox, let me ask you, would you expect that the attorney for the defendant would sit there silently during the interview?
I would think for the most part, yes, but there may be instances where he might want to advise his client about uncharged prior conduct. Often the qualified examiners will ask, have you committed any other sex offenses?
Oh, you know
Well,
that. Well, go ahead.
Yeah, right.
You know that's not going to happen. Once the lawyers get in there, there's going to be objections to everything. They're going to be running down to the Superior Court judge on an emergency basis to try and get the questions answered. The whole process will become common. Now, maybe it's required by law that it happen, but he's not going to sit there like a potted plant.
And if the counsel is advising the defendant what to say during the interview, doesn't that render the whole purpose of the interview useless?
I don't think so. I think, first, the qualified examiner has enough experience, certainly he's required to, under the statute, to get through all the interruptions, if any, by the attorney.
Well, but that isn't the purpose. The purpose of having a qualified examiner is to make a determination regarding the defendant's predilections, if you will, not to have to sit there and referee what's objectionable and what's not.
And unlike the criminal context where the defendant initiates the whole psychological process, here it's initiated by the Commonwealth.
Is this a criminal context?
No. It's a civil context,
civil.
but some of the criminal concepts sort of spill over, I would suggest. And
Mr. Fox, I think if there's any light for you, it might be that counsel have to be be able to advise their client as whether or not to proceed.
that's my main argument.
Now, I understand, but isn't it clear in this case that a decision had been made to proceed?
A decision had been made not to proceed.
What? Wait a second. As I understand the sequence, counsel was appointed.
Right.
There then was an interview with one of the qualified examiners, which counsel was present.
There was an intervening step there. The attorney called the qualified examiner and advised him that he wanted to be present.
No,
that's a separate issue. The point is, I think that the Chief was getting to, and the question I have, is the difference between the right to get advice of counsel as to whether to undergo interviews and the right to be present. It seems to me
Yes.
pretty obvious.
Yes.
And you certainly, or counsel certainly had an opportunity to advise his client. Indeed, they'd already been through one interview.
Right.
So you had an opportunity counsel had an opportunity to advise his client.
And most likely did.
All right. So what's the problem?
The problem is he advised the client to have the interview only with the counsel present.
Well, isn't that mixing and matching?
It's, I think the respondent can request to have the interview under certain circumstances. And they may not be in agreement with the qualified examiner, in which case there should not be an interview.
All right, so the advice was go forward, but only if I'm present.
Right.
And then, so he knew that. And then the examiner came in and said, all right, I've tried to contact your lawyer. He's away on vacation. We can go forward without him. We can try to reschedule. I don't know if that's possible because my report's got to be in next week. I've got to file a report anyway, so it's up to you. So what's wrong with that?
I don't think it was up to Mr. Sargent alone. I think he was required to have counsel present to change the decision that had been made. And
Mr. Fox, let me ask you this. If somebody in your client's position insists that he will only go forward with an interview if counsel is present, and if the qualified examiner says, I will not conduct an interview with counsel present, or let's say starts the interview and the potted plant begins to talk and interrupt, and the qualified examiner says, I'm not going to continue the interview with counsel present, won't we get the result, which is that the qualified examiner will submit a report without having either had or completed an interview?
Basically, yes, unless the court rules that there is a right to have counsel present during the examination, during the interview. And I think that's not necessary to decide the present case, but it may be necessary if there is a retrial ordered.
These are civil proceedings, are they not?
They are certainly civil proceedings.
But I know they have criminal overtones.
They have due process protections due to the potential loss of liberty.
Sure.
What are they doing in other jurisdictions on this issue?
There is a dearth of cases. I found very few, and it's hard to extrapolate.
Are there any jurisdictions that support your position?
I don't think I've really found any
Start
on
one
the
step
issue
back.
of
Excuse me,
attorney
start
being
one
present.
step backwards. Are there other jurisdictions that have a statutory scheme that's similar to ours? If there's not, then obviously there wouldn't be.
I think in the cases I have seen, some of them deal with interviews occurring before a petition has been filed, in which case they've ruled there is no right to counsel, similar to being no Sixth Amendment right before process has begun. Some of the cases deal with the person who's already been committed, and he is going for a review similar to our Section 9. And I would suggest that might be a different circumstance.
Are there any circumstances in which we have said that when a medical examination of this type is being conducted, counsel may, the person who's being examined has the absolute right to insist that counsel be present?
No, it's in the criminal context, at least, it's been held to be discretionary with the trial judge. And I would suggest...
I was thinking of other circumstances. Any other circumstances?
I have not seen it, maybe in the matter of Laura L., an appeals court case. Attorney was present, and I think his participation was at least implicitly approved. That's the closest I can think of.
If the Constitution doesn't require it, and if the statute doesn't specifically require it...
I think the statute does require it. And if you look at a close reading of the statute, you see a right to attorney in Section 12D1 for the probable cause hearing. You see it later on in Section 14B for the trial. Those are pretty obvious that he should have counsel done, but you also see
Well, the right to an attorney.
Yes.
But the statute doesn't say you have a right to an attorney during the interview by the qualified psychologist.
I think it's implied.
No, but wouldn't its absence mean that it's excluded? Because if the statute specifically states right to an attorney at certain parts of the proceeding and is silent about right to an attorney during the QE
I don't think it is
examination.
silent. It's not
What is it?
loud, but I don't think it's silent. In Section 13C, the section dealing with the temporary confinement, that 60-day period, it does say he has a right to counsel. And I would suggest the only...
At the qualified examiner's
No,
interview?
just during
No.
that period. But
Okay.
I think implicit in that is the only advice, the only real substantive advice he can give his client at that point that can't be done at any other stage is whether or not the respondent should cooperate and participate in the qualified examiner interview. So I
Mr.
think there is a
Fox.
statutory basis.
Mr. Fox, when we look at this record, will it be clear from the record that your client agreed to undergo the second examination, which is the one we're talking about, correct?
He agreed, yes, but improperly.
Only on the condition that his counsel was present?
Initially correct.
Well, you say initially correct.
He agreed...
No, I'm just asking what the...
it was a qualified original acceptance to participate.
Is that clear from the record? I'm not talking about what happened when the scheduling changed. At the beginning, was it clear that the Commonwealth was on notice Because under the statute, your client had a right not to be interviewed, correct?
Correct.
And the Commonwealth had a right to have a qualified examiner prepare a report without interviewing, correct?
Correct.
So we don't have any coercion here. The client says, I'm not going to participate. Or the client says, I will participate provided that my attorney is present. Is it clear from the record that that was your client's position?
I believe that is clear from the record.
And where would I find that? Is it a letter to the Commonwealth? Is it a...
I believe it would be in the motion of the trial counsel to exclude it. I could not find the transcript for hearing on that motion if there was. It would be implicit in the judge's findings.
Well, isn't it implicit also in the fact, if I recall the fact situation correctly, that the qualified examiner called the defense attorney and then found out that he was on vacation?
I'm not sure who called who. I got the impression the defense attorney called the qualified examiner.
Well, then if he called her, she would be on notice.
She was on notice, and I think...
Well, it depends. It's one thing for counsel to say, I would like to be present. Your claim is that your client should have a right to consult with counsel when he has agreed to undergo an examination, provided that his counsel is present, and now he's being asked to undergo an examination without counsel, correct?
Right, there's a completely different change of circumstances.
Right. So it is quite important that the record establish that the Commonwealth was on notice, that your client had not agreed to an interview unless his counsel was present. And as I looked at this record, I couldn't see that. I can infer things, but many counsel will phone up and say, I want to be there. But it's not at all clear that the client has decided, right?
I think it's there was nothing specific as to the statements of Mr. Sargent, but I think that can be imputed from what the
I know
lawyer...
you're asking me to impute it, but here where you're saying a client exercised a right and he had a right to consult his counsel before he was asked to change that.
Correct. And I think that is clear from the record, enough for this court to make that decision.
Assuming that that is the case, is exclusion of the report the only remedy? Assuming that the record is clear and assuming that we conclude that your client has a right to consult with counsel before the Commonwealth changes the terms on which the client agreed to go forward.
I would think it is the sole remedy.
And how does that benefit your client? Because if we play this out, one of two things would have happened. He would have consulted you. I realize you're appellate counsel. He would have consulted his lawyer, and his lawyer would have said, no, don't go ahead with the interview. And the qualified examiner, she would have submitted a report, or the lawyer would have said, go ahead with the interview, in which case we would have had the same thing, correct?
You'd have a different report, I would suggest. In this case, certainly, according to Dr. Quinones, Mr. Sargent made many comments, many statements that contradicted other statements of his or contradicted earlier records. These would not be in her report if he did not participate. Equally importantly, this interview...
Well, you're assuming that the Commonwealth would have agreed to go ahead with counsel sitting in the interview and presumably objecting. And so we get to the second question, which is what's the basis of saying that the Commonwealth cannot refuse to go forward with an interview if the client has insisted that the lawyer be present?
I would think, first of all, the interview is initiated by the Commonwealth. It's not something that Mr. Sargent or the respondent in general tries to put an issue in. This is the Commonwealth's decision. And second, the issues to be determined in the interview are those that are central to the case, much more so than in the criminal context. So I would suggest the right should be slightly greater in this case than in the criminal context. As my time is running up, I will rest on my brief on the other issues, and if there are no further questions, and thank you.
Thank you, Mr. Farr.
Good morning. Ellen Lazar-Moore for the Commonwealth. In Commonwealth versus Trapp, a first-degree murder case in which the defendant faced a potential life sentence, this court held, in line with the Supreme Court's decision in Estelle versus Smith, that although the decision whether to undergo a psychiatric examination is a critical stage of the proceedings so that the defendant has a Sixth Amendment right to counsel at that point, the examination itself is not. In SDP cases, which have always been held to be civil and remedial, and to which the Sixth Amendment and the so-called critical stage analysis therefore do not apply, there's nothing that warrants a different approach.
If the respondent makes an incriminating statement, though, during an interview, isn't that statement going to be used against him in court?
Well, first, this court has said in Commonwealth versus, Sheridan petitioner at 412, if I could get Mass 599, that information provided during a court-ordered QE examination cannot be used for later prosecution. In terms of the statement being used within the civil SDP proceedings, there's nothing wrong with that. The defendant is warned at the outset of the proceedings that anything he says will not be confidential. And, of course, he does generally have a right to counsel during this period, although not at the qualified examiner interviews. And under the statute, that attorney is required to be provided with the same materials that the qualified examiners are given. And so certainly counsel would be expected to advise the defendant about areas to talk about and not talk about, even if the attorney can't be in the room.
So the statement will be used against him, but it's supposedly okay because it's a civil proceeding.
And because he's been warned.
Ms. Lazar-Moore, let me just
Yes.
see if I can make sure that I understand what the Commonwealth's position here is. It is your position that he, at least under, as I understood it, that he has a right to consult with counsel about whether or not to proceed with an interview, correct?
That he generally has a right to have, he has a right to counsel during that 60-day period of evaluation, and certainly one of the things that counsel would be expected to do.
So the answer to the question is yes. He has a right.
But not that he's deprived of that right to counsel necessarily if he can't communicate with counsel at the moment the QE walks in the door. This case is very similar to Commonwealth versus Contos, in which this court held that a defendant was not deprived of the right to counsel when his attorney was not informed of exactly when a psychiatric evaluation would occur because he knew that the evaluation was imminent. And
No,
so,
I understand that, but Contos is a little different because if I recall the facts in that case, the attorney simply hadn't consulted with counsel, correct? I mean, the attorney hadn't consulted with his client, and there had been some period of time. And what the attorney was essentially saying is, I should have been given notice that on X date the qualified examiner was going to try and reach my client. Then I would have known that I had to get, my act together, so to speak.
As I recall the facts in the case, the client had already been examined, and then the Commonwealth had requested the opportunity to have the client examined again by the Commonwealth's expert, and the defendant's attorney had objected. The judge had allowed it. So after the examination occurred, defense counsel objected to it, saying, well, you knew I objected. I should have been told exactly when the evaluation was occurring so that I could have essentially told my client
in this
not
case,
to do
what do you make of the fact that the examiner actually attempted to reach his counsel? And if counsel had not been away on vacation, it seems that the examiner would have arranged to have his lawyer there.
What I make of that, frankly, Your Honor, is that although it's my position that there's no right to have the attorney at the
Being a
QE
nice
interviews.
person. She's been a nice person.
It's up to the qualified examiner whether to allow counsel to be there upon
Mr.
request.
Well, let me just ask you about that and see if you can think of other circumstances. In the criminal context, where the defendant places, his mental processes, whatever it is, competency, a whole variety of things at issue, we have said that the Commonwealth has a right to interview the defendant, correct? And
Yes.
has a right to interview the defendant without the presence of counsel, but that, as you and Justice Cowan just, agreed, nothing that's said can be used against him in a later prosecution. So that's clear.
Right.
In the civil context, any civil context, you take a deposition, you get information, and you can say all kinds of things that can be used against you. But I can't think of a single situation in a civil context where you would be deprived of the right of counsel, where there's no concomitant inhibition on what the Commonwealth can do with that information.
Well, Your Honor,
So in this case, and we get lots and lots and lots of situations where counsel are present, and some of the most damaging and revealing things are said because the person is under oath or for whatever reason, and counsel sits there and, you roll your eyes because the client is just hanging him or herself. But if there's no limitation at all on the use that the Commonwealth can on what use it can make of the information that's conveyed, why wouldn't we give somebody a right to counsel?
well, first, Your Honor, I would say that in Commonwealth versus Woods, which was a post-conviction probationary situation, this court did hold that there was no right to counsel at a psychiatric evaluation. So that is a case in which, in similar circumstances, when the respondent is no longer a criminal defendant, when admissions may be made during a psychiatric evaluation, this court again held that there was no right to counsel.
And did we say what use could be made of the information?
Well, certainly it could be used during the probationary proceedings. So that's
Isn't the answer
first
to this
portion of the
problem
answer.
that this is heavily controlled, regulated by statute, and it's a civil proceeding, and the statute makes no mention of having a lawyer at these kinds of interviews, whereas it makes mention of having a lawyer at other parts of these proceedings. So by reason of exclusion, it's not like a civil case. We have a
Yes.
statutory scheme here that takes care of the problem. So we would have to graft onto it some kind of gigantic due process right.
Yes, Your Honor, and not only by reason of exclusion, but also by the fact that the legislature amended Chapter 123A in 1999 after this Court's decision in Commonwealth versus Trapp. So certainly, had the legislature intended a respondent to have counsel during psychiatric interviews, it would have been expected to say so explicitly. And even in the criminal context, under the Sixth Amendment's heightened analysis, this Court has held that there is no right to have counsel at the interviews. Counsel is also not required to ensure that these respondents receive a fair trial. In Estelle v. Smith, the Supreme Court stated that even under the Sixth Amendment, a criminal defendant has a right to counsel where counsel's absence might derogate from the accused's right to fair trial. There's never been any suggestion that respondents in these cases cannot and do not receive a fair trial. They are warned that nothing that they say during the interview will be confidential. The examiners write reports of their examinations. They're present for cross-examination on the report and on their ultimate opinion. And in fact, in Commonwealth versus Gomes, this Court upheld the version of Chapter 123A that was in place in that time, under which respondents were not even appointed counsel until after the QE exams were completed. Now they
Let me
have...
ask you this, though. Let's go back to the beginning here, and that is the right, there is a right of the respondent to refuse to go forward with the interview. Correct?
Yes.
Right? So let's assume that he's exercised that right. And I think maybe we can assume he exercised it here. I won't go forward with the interview unless my lawyer is present. So he's exercised that right. Doesn't he have a right to consult with counsel if the Commonwealth is trying to change his mind?
Well, first I would say that in this case, he did not, in answer to Justice Marshall's earlier question, he did not condition participation in the interview on the presence of his counsel. He asked if counsel could be there, and in the record on page 13 is the respondent's motion to dismiss that he filed in the trial court, where he said that both he and his lawyer wrote a letter to the treatment center asking that counsel be present, but he did not condition participation in the interviews upon the presence of counsel. But even assuming that he had, as I had said earlier, although
that's in your appendix?
No, that's
It's
in
on the blue
the
brief,
respondent's
yeah.
appendix.
If we look at comparable mental health statutes involving civil commitments outside of the SDP area, there's nothing in there that says counsel has to be present for psychiatrists and psychologists and others interviewing these folks. They can either say we don't want to be interviewed, or they can go get interviewed.
Yes,
And this is a mental health proceeding, is it not, of a civil nature?
It is, and almost every court that has examined this issue, including this court, well, not the issue, and it's not in the SDP context, but in a different civil context, in the Nolan case, which is cited in my brief, this court noted the potential harmful effect upon psychiatric examinations if a lawyer is required to be present. And in the amicus brief filed by the Department of Correction, there are many state and federal jurisdictions cited in which, and one in the California sexually violent predator legislation in that context, where the court has a lengthy discussion of that. Also in the Byers case, Justice Scalia, his opinion on essentially how the rapport between a doctor and a subject in a psychiatric examination is so important in the doctor reaching an accurate diagnosis, and that interjecting counsel into this can only lead to a less accurate opinion. And I would also note that under our statute in particular, this court has repeatedly stressed the mandatory and inflexible nature of the timing deadlines in the statute. And although the qualified examiners are given 45 days from the date of the probable cause order to issue their reports to the court, in reality, when you factor in the time it takes to receive the probable cause order, get the materials regarding a respondent, assign a QE to the case, have the QE review those materials, and then schedule the interview, leaving enough time to write the report and get it to the court, it's actually a much smaller window. And if we are required to factor into that now the schedule of attorneys, that really will make it even more difficult as a practical matter to meet these mandatory deadlines.
Let me ask you
To go back to Justice Cordy's question, and that, as you could hear at the beginning, I didn't see an unequivocal saying, I won't go forward with this interview without. But assuming that that is the case, you know, and the Commonwealth is on clear notice that, you know, my client has a right not to go forward with an interview. My client has agreed to go forward with an interview, provided only, and there's nothing to say the Commonwealth couldn't agree with that. In fact, I can think of lots of reasons why the Commonwealth would want to agree with that. If there's then a change, I mean, in other words, you know that quite early on, surely in those circumstances, not present here likely, he would have a right to consult with his attorney, correct?
Yes. Yes.
Okay.
Oh, you do say that?
That had he explicitly conditioned participation on his attorney's presence, and then the Commonwealth for some reason insisted that he had to go forward without his attorney, that he would have the right to discuss with his attorney whether to go forward or not.
Right.
He certainly does have a right
And
to
that you can
counsel
do
during that 60-day period.
And you can, one can do that, presumably, by telephone or, you know, some...
Yes.
But that's not
But
the
that's
case.
not the
That's
case
not.
here, because he didn't explicitly condition it. And as you noted earlier, he did go forward with the prior interview. And as in the Contos case, of course, they knew that the reason for the 60-day period was for his evaluation and diagnosis. They were nearing the end of the 40-day period when the reports would have to be turned in. So they knew that the examination by the qualified examiner was imminent.
Well, they went forward with a prior interview, but of course with counsel present. basically on the terms of the consent.
Yes, but again, it was never explicitly firmly conditioned on that, and so although he had a right to counsel to generally advise him whether or not to participate in the interviews, there's every indication that he had been advised to participate in the interviews.
Thank you, Ms. Zardmore.
Thank you.
We'll take a short break.
All right.